After 10 years living together, she discovered she had no legal right to the home because her name wasn't on title. Does living together automatically give you the same rights as a married couple in Ontario? Today, we're breaking down what the law actually says and what to do to protect yourself. Many people in Ontario are choosing to be in a common law relationship versus getting married. And they're doing this for a variety of reasons. For some people, it's personal. They're not impressed by the marriages that they've seen or maybe the marriages of parents before them. It's just not something that they want to follow in, and it's like not for them. For some other people, they've been through first and even second, third marriages and just they're done. They don't want to ever have to do that again. And I get it. And for others, it could be financial. Let's face it, the cost of marriages these days, it is prohibitive. So a lot of people are saying, well, why do I have to spend that money just because I want to get married? And, they choose to live common law, and that's fantastic. But there are hidden risks with being common law, so you need to be aware of that. For starters, you don't have the automatic right to equalization. So for those who are married, if there's a breakdown of the relationship, then you automatically have a 50-50 split in. Now, that doesn't mean that would necessarily happen, but that's usually the starting point. For common law, that's not the starting point. The starting point is generally in whose name it is a property. Another hidden risk you should be aware of is the fact that there might be confusion over your entitlement to spousal support. And this has to do with how the Family Law Act defines who a spouse is for spousal support purposes. So that's something to be mindful of. And the other is there could be surprises upon death or separation, right? With things like other benefits and other things that are related to, maybe your employment, your beneficiary designations and what kind of benefits a spouse could get under that. It could vary if you're married versus divorced. But from a Family Law Act perspective, if a person is married upon death, you can ask for the person's property to be divided equally rather than having to take under the will. So what that means is you get a period of time within which you can say, well, I don't want to get their property based on the will for whatever reason. I would rather go through an equalization process and have our assets divided 50-50. So who is a common law spouse in Ontario? Well, a common law spouse is a person with whom you've lived in a conjugal relationship for at least 3 years. Okay, so live together, conjugal relationship 3 years, or if you have a child together and are in a relationship of some permanence. So in that case, you don't have to meet 3 years. You have a child together and you're in a relationship of some permanence. That's what makes you common law in Ontario for spousal support purposes. This definition doesn't necessarily count when we're dealing with property division. But one thing I want to clarify is that there is no such thing as a common law marriage in Ontario, okay? It's just you live in common law or you're married. So, like I said earlier, for people in common law relationships, if the relationship ends and there's a property, so, we're talking about someone who found out after 10 years that they had no legal rights in the home because their name wasn't on title. And that's just how it works with common law. When you're in a common law relationship with someone, it follows title. That's kind of how division goes. So essentially what's in your name is yours. And if it's not in your name, it doesn't matter. Now, there is a way around it. There's trust claims that you can make to ensure that, some fairness is achieved. But that's something that you need to understand when you're making that decision between whether you want to be married or common law. Just be mindful that you do lose that equalization. And it is major. It's a major right because a lot of people do not expect that would be the outcome. They imagine that because they're contributing that, there will be something for them at the end of the day. I want you to also be mindful of the flip side. There are some people who are married and kind of think that things work the same way as it does for common law, just simply because title is in their name. And that's completely different. Well, not completely different, related subject, but that's not what I'm talking about here. So here I'm talking about, if you're in a common law relationship, you want to be mindful because you may find yourself a long time later having to fight and scrape to get anything out of the relationship. And if that's the intention, then that's okay. But I find that a lot of times it's an unintended consequence. People have contributed to, the acquisition of a property and the preservation and improvements on a property. And now they'll be walking away from that property with nothing. But remember, I said there are ways around it. There are trust claims you can bring, but it's so much more complicated. and there's no guarantee what amount you would actually get at the end of the day. So here's how to protect yourself so you don't end up as another cautionary tale, okay? We don't want to have to deal with the breakdown of a relationship several years later, and now you've invested all of these monies, and because you're not on title, you have nothing to show for it. So let's start with the very beginning. Contracts, cohabitation agreements are specifically designed for people that are going into common law relationships. So if you're not getting married, don't do a marriage contract, do a cohabitation agreement. And I know a lot of people think prenups, and you're thinking, well, that's something that only exists for those who are getting married. Well, the beauty is in Ontario, Canada, you can do a cohabitation agreement if you're going to live common law with your partner. In the cohabitation agreement, you can define your rights and your responsibilities. So, what would you pay for? What does that entitle you to if the relationship ends? You can get creative. Do you want to have more entitlement as the relationship grows and, you're in the relationship for a longer period of time? Or do you just want to have, a fixed percentage of how things would be divided? So you have a lot of control over how things turn out in the unfortunate event that the relationship breaks down. Another way to protect yourself if you're in a common law relationship is make sure that if there's any intention that you share any property, make sure that it is put in joint names. So if you are, owning a property together, like a house, make sure your name is on title. And even if you're not going on title as a 50% owner for whatever reason, maybe, you're bringing in less of a down payment, whatever the case may be, could be tenants in common. That's the way you will take title, as tenants in common. And as tenants in common, you could even have 10% share of the property, for example, if for whatever reason, that's what, you agree to with your partner, if that's what is appropriate in your circumstances. So you need to be mindful of how you take title to property, making sure that, you put your name on title if the intention is that you should have some sort of ownership interest in it. I'll also say be very careful with your estate planning, because you want to make sure things like wills are in order and beneficiary designations are done right and all of that. The last thing you want is for your spouse to pass away and now you're having to again fight and script because you're not the married spouse, and maybe under that plan you're not automatically recognized as a common law spouse to be a beneficiary under that plan. So if there's a will and things are set out clearly, then that could help kind of mitigate against those kinds of things. So those are some tips to think about. And lastly, I would say learn to normalize talking about your finances, talking about your future. People talk about a lot of things. If you could talk about how you want things to go, especially when it comes to things like estate planning. But I'm a big fan of having these conversations very early on. I think people should have that agreement very early on in the relationship and be done with it. So one and done. Just decide how you want to organize your affairs, get the agreement done, and then move on with your life, live together happily ever after without ever having to think about that agreement. Of course, if things go wrong, then thankfully you have that agreement. It's time to whip it up. And it prevents a lot of fighting on both ends, right? So even on the part of the titled property owner, if your intention was, well, I would like them to have, 20% of this asset because that's all they contributed to, well, then you save yourself having to be in a fight with someone that thinks they're entitled to 50%. Again, because communications weren't clear, there was no clear agreement. All it does is create conflict in the event that there is a separation. So don't let that be you. Protect yourself. So here's what I would like you to take away from this video. Common law spouses and married spouses in Ontario are treated very differently. And the most important difference is that they do not have the rights to equalization that married people do. So you want to make sure that you protect yourself. If you want to have a right to share in property, make sure that your name is on that property. If you're living with your partner or separating from one, book a consultation with AP lawyers so you can understand your rights and how best to protect yourself. And follow us for more real legal, emotional, and financial insights.